and it pains me to say this, that this bond virtually is illegal. I will reset the bond in an amount of $500,000.
Oh, you're not concentrating on behalf of Mr. Floyd, who I believe is attending via Zoom.
State your name, please.
Mario Floyd.
Yeah. This is people's motion.
Yes, Your Honor. Thank you so much for setting this very quickly so that we can be heard. I know the court has reviewed the motion. I'd like to start with a couple of housekeeping matters.
Yes.
I know this preacher got appointed this morning. So I had an extra paper copy of the police report that I gave her in court this morning, but I know that she hasn't had the benefit of reviewing a lot of the discovery in the case. So I just wanted to put that on the record. And mostly, Your Honor, we're here today asking the court to reconsider the bond. In my written motion, I did indicate that the defendant is charged with a variety of extremely serious offenses, including but not limited to armed robbery, carjacking, assault with a travel, armed larceny from a person, so on and so forth. My understanding is that the defendant is currently on juvenile probation related to his PhD. He has been not compliant with that probation, most recently being put back into detention in February and released back out to his mother in March. And in this case, he was in Ann Arbor after midnight with one other individual at the time of the armed robbery, but with a group of other individual times later than the armed robbery, a group of 4 juveniles and 1 adult, ultimately an entirety of 5 people. I do believe that the likelihood of conviction is extremely high in this case, as the disarmed robbery and carjacking was captured on video from the Bell Tower Hotel. Very concerned with the safety of the community, mostly a bit concerned about the defendant's ability to comply with court orders, given his probation and non-compliance there. People do recognize the defendant is extremely young and will turn 18 later this month. But we do believe that the PR with the home confinement tether is an abuse of discretion. We ask the court to revisit the issue of bond. Happy to answer any questions the court has. Thank you, Your Honor.
All right. So, Richard, I realized we were notified that you were being appointed to the case last night, but I don't know. Are you prepared to address the issue of bond at this time? Or?
I am, Your Honor, for the following reason. First of all, the standard, we all know what's the standard. Okay, so, and then I did have an opportunity to speak to my client's mother and my client. So we are ready to prepare.
Go ahead.
Okay, so we'll understand that the standard here, I'm sorry, I didn't ask my arguer at the table.
That's right.
Okay, thank you. Abuse of discretion. And that is abuse of discretion happens when it is manifestly unreasonable, arbitrary, or based on a clear error of law or fact, rather than merely being a decision an appellate entity such as yourself would have made differently. The standard recognizes that the magistrate had firsthand knowledge of the case, including arguments made by both sides.
Before you go on with that, understand that, as is customary for me with these motions, I have reviewed both the swear-to video as well as the arraignment video. So I am very well aware of what the magistrate was seeing, but you may go ahead with your...
All right, then I'll skip that. Okay, so it's my opinion that based on it, the magistrate was in the best position. He had all the facts to make a decision. I understand the seriousness of what the crime here and the seriousness of the accusations and allegations that Ms. Feltes brought up. My client here in the courtroom, his mother is here. He has family support. I've spoken with his mother and she is willing to allow him to come back into her home.
How do I reconcile all of that with the fact that this defendant now faces 3 life offenses, was on probation for a CSC third, did not comply with that probation, was basically detained in the detention center by Judge Conlon for a period of about 30 days plus, and didn't make it 50 days from being released from that before he's back in police custody on these felonies?
Well, You reconcile it this way, Your Honor, because, it's a tough question to answer, but I want to do my best, okay? You reconcile it because he, in speaking to his mother and speaking to him, he understands the seriousness of this. And that's how you reconcile it. I mean, I get where the court's coming from, but this motion has to be, addressed. And, I appreciate the court listening to my arguments, but I think that there's other ways to ensure public safety. And that.
How do I not consider it an abuse of discretion where the co-defendant, as I'm to understand from the swear to, was standing between the victim in this case and the vehicle in a position that it's believed was going to stop the person from going to the vehicle, that this defendant actually pointed a pistol at the person, then struck the person with that handgun and took the phone. And this defendant did all of that. He has a PR. The other defendant who was standing there equally is liable for what's going on. But that person gets $100,000 cash surety bond. None of this, I'll be honest with you, and again, I'll listen to you, but I'm telling you from where I'm starting, none of this makes any sense to me.
Well, I can appreciate the court's candor. The court's going to make their decision. And, that's the court's prerogative to find an abuse of discretion. I mean, I don't have information as a swear to. I don't have the $100,000 bond that was set on the co-defendant. All I can say is that I believe it was Magistrate Odatello made that call, and he had the information. He had all of this information, I presume, because I haven't seen that video. I'm assuming, and maybe I'm incorrect in assuming, but he made that decision based on the information that they have. Now we're hearing it. And if the court feels it's an abuse of discretion, it's within its power to do so. I'm saying that if the court is, just apply the standard that I rattled off earlier, my client has family support. My client, I've had a conversation with him. He understands that whatever court orders that is followed, if he's able to post bond and release on bond, then that he has to follow his court orders. The family is suffering through financial hardship. In the home, it's a single mother home. There are 5 children, including my client, so there's 4 still at home, and she is the sole provider. So I'd ask the court to consider that when assessing bond, that, the family high bond would be financial hardship, and if possible, allow him to have a 10% privilege run. Thank you.
Ms. Feltus.
Because it is my burden, Your Honor, I just have a couple of more things I'd like to point out for the court. I want to make sure it's very clear. This firearm was a BB gun. It wasn't a pneumatic gun, but it is incredibly realistic looking. I would ask if I've shown this to Ms. Kracher, if the court would consider looking at a photo of this to see how realistic this looks. I do think it's important when we talk about this to realize that. If there's no objection from defense?
No objection.
It's not labeled or anything, Your Honor, and I'm not admitting it, but I just want to see the firearm that was recovered. I didn't say the weapon. I didn't say firearm. I should say weapon. In my experience, this looks like a Glock, Your Honor. And honestly, it is amazing to me how real it was. It's the orange chip. It's lit black, the dark gray black. And the last thing that I will just let the court know, I've already covered. I'll rest on everything I've already said. Thank you, Your Honor.
Anything else, Ms. Kirk?
Just what I already said before, especially about the financial hardship of any high bond would produce on the family, Your Honor. Thank you.
The court, upon receiving the people's motion, they've indicated read the motion, reviewed the swear to. I also reviewed the arraignment so that I could fully understand what information the magistrate may have had at the time that the decision was made. I tried to give deference to the magistrate's decision regarding this. I will be quite frank with you, it is impossible for this court to do that in this case. The bond as set in this case, with all due respect to the magistrate, it's illogical to me. It makes no sense. I have someone, as I previously indicated, who is on or under sentence on a CSC 3, has not complied with the conditions of that probation. How would I even believe that that individual would comply with just conditions on bond on a capital case times 3? It doesn't make any sense to me. Further, that there is an indication, and I'm not sure why this was not taken into account. There is an indication that this might be a ring of individuals involved, some of them juveniles, and so that this not only is some isolated incident, but that this defendant may be involved in effectively a criminal enterprise that clearly would jeopardize and pose a risk to the community at large. I think and it pains me to say this, that this bond virtually is illegal. Because, first of all, he's on bond and commits these offenses. Secondly, at the swear to, it was very clear that all of the elements necessary given this charge, all of the elements there regarding the presumption of guilt or the likelihood of conviction were there, that quite frankly, I'm not sure why his bond was not denied. We don't, in a lot of cases, get to see that, or certainly not at the arraignment stage, wouldn't be able to make that finding that this likelihood of conviction is there. This one is very clear. He's caught on video. The specific question was asked by the magistrate regarding identification of these individuals, and the officer in charge was able to, or the officer swearing it out, was able to articulate specific things that pointed to this defendant and his cohort as the people that did this. I'm not making a finding of guilt, but I certainly on that low standard for the purposes of bond, I don't know how one gets past it, frankly. Was there something you wanted to say?
I wanted the record to be clear to Your Honor, because the type of probation the defendant was on was juvenile probation and on adult probation for a violent felony. It wasn't immediately clear to me when I filled out the bond form if I had a reasonable basis to ask for bond to be denied pursuant to that provision of the court rule. And frankly, Your Honor, and I apologize, I didn't have time to do the research to get it done. And I wanted to ask the court for what I knew I had an ethical way to ask for, which is why we did not request that bond denied for a violent felony, because frankly, I wasn't sure if juvenile probation and violent felony was going to work in the same way that adult probation for a violent felony would work for the purposes of bond. I wanted the record to be clear about it, that people did consider that he was a juvenile that was on juvenile supervision probation as opposed to an adult, just so that we're very clear that that wasn't going to be thought about, but I didn't have time to do the research before getting it in.
I looked myself and I don't know that I saw anything definitive. I mean, the cold-hearted reality is that it was, I mean, when one looks at the purpose of the rule, it's that the person is under court supervision and monitored, and then this happens.
Thank you, Your Honor.
And so, yeah, I think I have stated everything I had stated on the record. I also will indicate I am not, well, I don't judge a bond based upon other bonds that are set. There is a bizarre discrepancy between the two individuals involved in this offense. And clearly, based upon what is being said, this defendant was much more clearly involved with the activities of violence and harm toward the victim in this case. For those reasons, and having reviewed everything that I have, I regrettably but don't have any other option but to say that the setting of a personal recognizance bond in this matter, given these charges, given what I know about the case, and having reviewed everything, is a clear abuse of discretion. The court will vacate that bond and will reset the defendant's bond. I will leave the conditions that were set by the magistrate in place, but in terms of the monetary amount, I will reset the bond in an amount of $500,000 cash surety.
Before we consider 18%, Your Honor.
I will not, and mainly also because I don't know that the defendant being on probation violating this, my opinion is not entitled to it. And I'm certainly not going to exercise my discretion to grant.
Thank you, Your Honor, for considering that. Just had to ask. Thank you.
Thank you, Your Honor. I will also let the court know in the schedule for probable cause conference 6 days.
Yes.
And discovery continues in this case and the investigation continues. And I do believe that we may have additional information by the time for the probable cause conference where the people may wish to revisit bond and our groups become even stronger to request that bond be denied entirely. I do think that's a possibility in this case, but I don't know it for sure.
Understood. All right. Anything additional?
On the people.
All right. Thank you.
Thank you.
The other, in my understanding of how this works,